All right, next case on our calendar today is 24-1266, Riverfront Associates, Riverfront Holding Company versus Jack Weisenbaker Construction and Jack Weisenbaker. 20 minutes per side. Would you like to reserve some time?
Yes, Your Honor. Sean Dixon on behalf of the appellant, Riverfront Associates. I'd like to reserve 5 minutes for rebuttal.
Okay.
And as you mentioned earlier, there's a process.
That's true. Thank you for reminding me about that. So would you like to reserve some of your 20 minutes for your...
Yes, 5 minutes, please.
Okay, great. All right, we may proceed.
Thank you. May it please the court. Sham Dixit on behalf of the appellant, Riverfront Associates. Your Honor, we're here on a very straightforward and simple issue, and that is the trial court erred in denying directed verdict on count 6, disgorgement, restitution, and refund. On that narrow issue, it has a large impact on the balance of the case and on the remaining counts and damages awarded, because once the jury found that the culverts were part of the stormwater system, then this meant that Jack Weisenbaker needed a Florida construction license.
This claim, this disgorgement restitution claim, it's equitable in nature, correct?
It is not, I would argue that it's not.
Okay, but it was, other than the stormwater system finding, it was agreed that the trial court would hear that portion of it. That was not a jury determination. Is that correct?
That is correct.
Okay.
That's right, because it's an interpretation of law.
All right, and so you reference Florida Statute 489.128 for the authority that your client's entitled to be reimbursed for the $2 million because a JWCI was not a licensed contractor. You'd agree that if a license was not required for the work, then that statute would not apply, correct?
If a license was not required, that's correct.
The statute says for the purpose of this section, if a state license is not required for the scope of the work to be performed, then the individual performing that work is not considered unlicensed. So we wouldn't.
That's right.
Right, okay.
It's very binary.
What's that?
It's binary.
Yeah, so but the trial court never really reached the issue of whether or not there was a license or not because they thought the statute only kind of worked one way. They didn't think it worked towards someone defending themselves, correct? So the trial court, as I read the record, I think the record's over like 40,000 pages.
Right, exactly.
But I think the trial court never actually reached the merits of whether a license was required or not based on their reading of the statute. Is that correct?
No. Well, it was stipulated that Jack Weisenbaker didn't have a license.
I understand, but for the project, I don't think did the trial court ever make a finding that a license was required for this work or not? I know what the jury found, but the trial court, because my understanding was the trial court, in their interpretation of the statute, did not go any further in finding whether a license was actually required or not.
I believe the denial of the directed verdict is the finding that a license was not required. That's where, correct, in her order on directed verdict, she didn't make any factual findings, but the only reason you would deny a directed verdict is because a license was not required.
So I thought her rendering, again, I thought her rendering in one of her orders was that her reading of the statute was that this only works for someone when they're trying to enforce the contract. I mean, it's like bringing a claim rather than the defending themselves. And I thought she said she was going to make findings later, but never did. Is that correct?
It is, and I think you're referring to the orders on the motions for summary judgment.
I am.
Okay, exactly. Because it was in the orders on motion for summary judgment, she did say, I need additional facts to determine whether a license is required.
So I would say if we were to agree that the statute worked both ways, for defending and for bringing an action, then, and we thought the disgorgement claim, we thought your claim was properly pled,
Okay.
then we would need to remand that, correct, for the trial court to actually make a determination whether a license was required in this case, correct?
I disagree with that.
Okay, and why is that?
Because the judge had a special question or interrogatory to the jury to determine whether it was a stormwater system. Once that fact was found, Chapter 49, 105 N3 says a licensed underground utility and excavation contractor shall hold a license. The Jacksonville Code 744.110 states that a construction in a stormwater system requires.
But she would still have to make that finding. I guess that's my question to you. She never actually, I don't want to say she passed on the issue, but it appeared to me her reasoning wasn't based on whether a license was required or not. It was based on her statutory interpretation. So she would at least have to go back and make that finding, correct?
Again, the only reason I disagree with you is because it's implicit in the denial of the directed verdict that no license was required. Otherwise, how do you deny directed verdict after the jury found it was a stormwater system? The fact that she was looking for post-summary judgment order, to your previous comment, it was the post-summary judgment order she said, I need a definitive fact as determined by the jury as to whether a license is required.
Okay, so let me assume your argument is correct, and I'm not saying, just assuming you're correct. There was testimony at trial that about 15% of this work was related to the stormwater drain system.
That's right.
Is that correct? Okay.
Yes.
So 85% of the contract would theoretically not have required a license. So can the trial court sever that? Let's say you're correct on the stormwater system. And I know Judge Scales, there was a case on the third DCA he concurred in, and he discussed this issue, saying that it had never really been addressed, this severance issue. So is that correct? I mean, would you then have to go in and sever out the part that required the license and the part that did not require the license?
No.
Okay, and why is that?
Okay, two reasons. First is you're defeating the purpose of the legislature's intent under Chapter 49. First, for example, 49.127.2a makes unlicensed contracting a crime, right? So it's penal in nature. There are no equitable defenses to it. There's no ignorance of the law. A Florida contractor's license is needed. Next, under 489.128, prevents unlicensed contractors from enforcing contracts. This court last summer in Cam Bradford Holmes v. Arendt found that a contracts entered into by an unlicensed contractor are unenforceable in law or equity by the unlicensed contractor. Next, 49.127 subsection 2 prevents an unlicensed contractor from placing a lien for any, quote, any labor, services, materials under the contract. Then Earth Traders, Florida Supreme Court, says an unlicensed contractor cannot even enter. It's a violation of the statute to enter into the contract, making it void ab initio. So my first argument is to sever unlicensed from licensed work shifts the burden of the penal nature of the statute to the trial court, which is inappropriate. That is not what the legislator wanted. The legislator wanted it to be binary, just like the unlicensed practice of law or the unlicensed practice of medicine. That's why I cited Vista Designs versus Silverman. There, the court imposed disgorgement without a statutory provision because regulatory measures made it a criminal offense to practice a law without a license. Our legislature is holding contractors to the same burden, level, and onus as other licensed professionals. And they're trying to reduce the amount of excuses, if you will, that would burden our legal system because now we're having trials on the severability of contracts. What our legislature determined is that the onus is on the contractor. Jack Weisenbaker could have entered into two separate contracts. He could have said, it puts the burden on the contractor to say, hey, listen, I'm not licensed to work in a city of right-of-way. I'm not licensed to install 1,000 linear feet of stormwater culverts, but I can move dirt. Moving dirt doesn't require a license. I'll enter into one contract, and you're going to have to hire a Florida licensed contractor to do the other work that requires a contractor's license. To argue severability shifts the burden to the trial court in violation of the legislature's intent to not have to do that. Once there's a violation of law, of violating the Chapter 49, it's binary. And Earth Trades even says the effects of that statute are draconian. It's meant to be penal. So by arguing or allowing severability, you're defeating the purpose of the legislature, period, under the case law and under the plain reading of the statute. And I would even say, but under 49-128-2, it's explicit that the contractor is rendered unenforceable and an unlicensed contractor cannot benefit for the quote, any labor, services, or material provided under the contract. So even a plain reading of the statute as enforced by the court makes it binary. There is no way for an unlicensed contractor to benefit under a contract for any labor or services performed, period. If any portion of that, and I cite several trial courts that have interpreted that statute in our briefs. And so there is no Earth Trades, and in fact, Cam Bradford and Vista, there is no appellate court decision like Vista Designs, where they take it to say that the remedies are X once there's found to be a Chapter 49 violation. I think that's what caused.
So disgorgement is a remedy, you would agree with that, correct? And I know you also would title it restitution. Are you really making an unjust enrichment claim? Is that really the claim that you're making here? Because the argument that they make is that your action is for disgorgement, which is not really an action, it's a remedy. So, but you also have restitution mentioned there, which is a legal, which I think the case law says is a legal action. But do you plead the necessary elements to get there? Is that really an unjust enrichment type action, or are you pleading those elements?
An unjust enrichment action is separate than enforcement of Chapter 49, right? So in other words, unjust enrichment exists in a world in which either the contract was unenforceable for some reason other than the violation of a statute. But, for example, an unlicensed attorney.
So how do you view this claim that you're making? That may simplify that for you. Like, how are you, what is exactly that you're arguing here?
If a contractor or an attorney performs work perfectly, not a defect in the house, the punch list is perfect, everything's fine. In fact, this is one of the arguments that we had in the trial court. Is the contractor, or am I the homeowner, unjustly enriched by accepting the home from the contractor who performed this work without a license? The Florida legislature said no. There is no way to justify or excuse a statute that's criminal or penal in nature. No more than I can write a will without a law license that gets probated in court perfectly, and I would still be sanctioned. I would still be a crime, and I would not be able to benefit in any way from those actions. And so unjust enrichment kind of gets back into that world where there's no statute that's penal in nature. And again, my argument is that it's binary. There's no scenario. Once there's a violation of Chapter 49, the contractor cannot benefit in any way. It's not about me, the consumer. It's not about the onus is not on me to show that the contractor's unjustly enriched or I am unjustly enriched. That's not part of what the legislature's determined for. I think the point of the legislature in making Chapter 49 is to hold contractors to that sort of professional level of standard that reduces the stress on the consumers or the need the person who is in need of the contracted services, and the court systems. They don't want trial judges to have to determine whether there's severability, whether there's unjust enrichment, or any other issues. It's penal in nature, draconian, again, citing earth trades. So once this violation occurs, disgorgement is the only proper remedy. If you received $2 million or $300,000 for building a home, the only proper remedy for violating Chapter 49 is to disgorge any benefit whatsoever, because that's what the legislature did when it drafted 49.128 subsection 2. And all the appellate decisions prior to this one, frankly, hopefully, take it to that point where they find there are no defenses in law or in equity. The contract's void ab initio. The contractor cannot defend itself. It's just a matter of determining what benefit, if any, the contractor received and or penalize that contractor for violating Florida law. And for those reasons, Your Honor, I'm going into my rebuttal period, but for those reasons, that's why we ask that the appellate court determine as a matter of law that a directed verdict should have been entered on count 6, disgorgement and restitution. Unless you have any further questions, Your Honor, I'll wait for my rebuttal.
Great. Thank you, counsel.
Thank you.
May it please the court, Diane Tutt on behalf of the appellees cross appellants. I'm going to, of course, address the disgorgement claim first, and hopefully I'll have some time to get into the cross appeal. I want to start with the standard of review. This is clearly an equitable claim. The parties agreed it was an equitable claim, and that is why it was decided that the judge would decide it. I don't have a record cite for that, but it's clearly something that was agreed to below. There was never a time in which counsel argued that we could not make our equitable arguments in opposition to the disgorgement claim. If you look at the post-trial hearing, that would have been on February 28th, 2024. It's volume 18 of the transcript. You will see that I made all the arguments that I made in my brief and that hopefully I'll have time to make today as to what are the equitable considerations that the judge should use in deciding this equitable claim. Counsel addressed each claim or each argument that I made, but never said, no, this is a legal argument. You can't even argue any of these equitable considerations. Now, I don't want to mislead the court.
statute, though, covers, the statute itself at issue says, does not allow the contractor to, it appears to not allow them to make arguments in equity, correct? I mean, it says by an unlicensed contractor should be enforceable in law or in equity by the unlicensed contractor.
It does say equity, Your Honor, but what it's talking about, and this is really my main argument as to why counsel's argument is not well-founded, is that that statute only says that the unlicensed contractor cannot enforce the contract. It doesn't say anything about this binary argument that's being made today. And as I cited a case law in my brief, the legislature knows how to say something if it intended to say something. Counsel keeps saying, well, the legislature clearly in this statute said that the contractor cannot benefit. It doesn't say that. It says an unlicensed contractor cannot enforce the contract, meaning they cannot sue to enforce the contract. Interestingly, in this case, there were breach of contract claims by both sides. The Riverfront won on its breach of contract claim.
Haven't courts said that they can't bring defenses also?
There was some summary judgments of certain defenses. We were allowed to raise two defenses.
Does that cut across your argument?
No, because Earth Trades clearly stated that if the contractor is being sued for breach of contract, then he cannot make what was the impera delicto defense, which is what was involved in earth trades. They cannot raise that. We had one of our defenses the judge struck, I can't remember which one it was, based upon that same theme, but that was a defense. There's a far different difference between an affirmative defense or a defense to a breach of contract claim versus a disgorgement claim that is nothing in the statute mentions disgorgement. Nothing in the statute mentions that an unlicensed contractor cannot benefit in any way by their contract. And the fact is that disgorgement is an equitable action. And I would like to just spend a couple minutes on the standard of review. The standard of review is clearly breach abuse of discretion, clearly. That's been argued to the judge. It was agreed that this was an equitable action. There's no dispute in the case law that equitable actions, in inequitable actions, the courts are required to look at all the facts and circumstances surrounding the claim. And that is what we presented to the judge in this case. We presented this idea that you brought up, Judge Boatwright, about the fact that it's an over $2 million contract, but the culverts, which were the only things that were alleged to have required a license, was about 15% of
Did she ever make a decision, though, whether a license was required or not?
No, she did not.
She based it on your statutory, how you view the statute.
I have to admit, I don't know. It was a simple denial. There was no analysis. At the hearing, she did not make any oral rulings. She entered her orders. And on this particular issue, because we addressed various post-trial motions, on this she just said denied. And I know there was a suggestion that perhaps there should be a remand, but I submit no remand, but not for the reason that counsel indicated, because it's waived. If in fact you believe that the judge should have made some findings, i.e., was there a license required or not, then that's something that the appellant must bring to the trial court's attention before they appeal. Now, I don't have the case in my memory at this moment, but there's a summary judgment case, as we all know. Now, in summary judgment, you have to the judge has to make findings. And there's a case that says that if the judge doesn't make findings and the appellant doesn't bring that to the judge's attention during the rehearing period, then they waive that argument on appeal. At this moment, I think we have to take the abuse of discretion standard at face value and say that, the judge had all of this in front of her. She did not make a decision whether there was a license or not. But let's just say she had in her mind found that there was a license. It's an equitable action, so she's still entitled to consider all of these other aspects. And I know this was a very long trial. It's a very large record. I think we're all well aware of the length of it. But, several times this issue came up about the statute. Several times the evidence showed that Mr. Weisenbaker reasonably believed that he did not have to get a license, and that is based upon some testimony by Mr. Turing, who is the administrator, architect of the project for Riverfront. And it was also based on a license that said it was for the culverts, but it was said right on there, license not required. And Mr. Weisenbaker was the one, he didn't apply for that permit, but he picked it up. And he saw that. So all of that evidence came up during trial, and the judge heard it, and the judge was entitled to determine that there was some, for purposes of trying to make a full disgorgement of over $2 million, that is one of the equitable considerations, I think.
The permit you're discussing was dealing with a stormwater system, the stormwater drains?
It said culverts. Now, there was some testimony that really was a brush permit, that it wasn't the actual, I have it right here. Somewhere. Nope.
But the permit itself from the
permit
city of
itself.
Jacksonville said they did not need a license, correct?
It said license not required, and then when it said what it was for, it said that it was for the culverts. Now, there was some testimony, and I can't find it, I'm sorry, but there was some testimony that actually it was the brush permit for that area. So there was a lot of confusion about this permit, but my point is, and I'm not making a representation to the court, that the city said there was no license required, because there was this testimony about, even though it said this was for the culverts, it really was a brush permit. But my point is that Jack Weisenbaker picked that up, and he testified that it said license not required. I didn't think I needed a license. And that might not be important in a legal cause of action, but it certainly is important in a restitution, in a equitable cause of action. And let me just, I want to address a couple
Counsel,
things.
if I could ask a factual question. The special interrogatory
Yes.
that had to deal with the culverts and so forth, the jury answered yes to it. Was the installation of the culvert pipes part of a stormwater system? And they said yes. So the culvert pipes were part of a stormwater system. What's the significance of that? I'm still kind of struggling with that,
Well,
because a stormwater system may or may not require licensure, but only thing that's at issue in this appeal is the culvert construction, correct?
There was a disagreement whether the culverts were for the purpose of tidal flow, because this is right on the river. You know, the land had to be reduced in depth so that the tides could come in because of the nature of this project. But there was a disagreement between the parties whether this was a tidal flow for these culverts were for tidal flow, or whether they were for storm water. And the jury found stormwater. And why this was significant to the plaintiff is two reasons. Number one, statute 489127 uses that term, stormwater system, saying that you have to have a contractor's license, and lists the types of contractors. But that statute is a penal statute. It has criminal penalties in it. There's no private private cause of action under that statute. The statute that's been relied upon is the next one, 489.128, which is the one that we've been talking about, where it says an unlicensed contractor cannot enforce a contract. The reason this stormwater language was also important is because the plaintiff relied upon a local ordinance, I believe it was 744.110, which also said that they listed a couple different categories, but for stormwater, you have to have a license per 489.127. We argue that that local ordinance wasn't applicable because that language that I just read, that I just mentioned to you, only talked about if a right-of-way permit is required, this paragraph is applicable. And that's another thing the judge never found, the jury never found. Was a right-of-way permit applicable? I think they needed that finding in order to have the local ordinance be applicable. But that was the relevance of this language on the verdict form. But the judge, it was conceded, of course, that she would decide count 6. And these were all considerations that were argued to her. The overreaching, asking for the $2.2 million return. The fact that Jack Weisenbaker reasonably thought no license was required, and a few other things that we argued, including that they simply asked for a remedy, not a cause of action. I think we all know what this is, what these claims are. It is
The
a
culvert
remedy.
construction was what percentage of the overall $2 million?
Say it again?
The culvert construction was what percentage of the overall $2 million?
As far as the money, it was about 15%
Okay.
of the total contract.
Any court-allowed severability in these situations?
Not seen that, Your Honor. In my opinion, because this is an equitable action, that was just something for the trial judge to decide. If she had decided that disgorgement was appropriate at all, I believe she could have said, in the interest of equity, I am only going to require disgorgement of the 15%.
Anything in the contract itself that allowed draws for different portions of the contract, or different portions of the project?
I know there were draws, but I don't remember whether there were for different portions of the project. The culvert were done fairly early, and, the other equitable thing I wanted to mention is they're operational, they're fine. I know council doesn't think that the propriety or the perfection of the construction makes a difference, but I think in equity it does. So I think that was another thing for the trial court to consider. Now, I just want to mention this void ab initio argument. That was never pled, that was never made below, argued below. In fact, at one of the hearings, counsel indicated, I think it was co-counsel indicated, no, we're not arguing void ab initio. Because if they were arguing void ab initio, and the court found that, then neither side could could pursue their breach of contract claim. So there's no, this void ab initio, I don't even know where this came from, because the plaintiff sued for breach of contract. The defendant sued for breach of contract. So the contract was not void ab initio. I think that the fact is that this being an equitable action, the trial court had it well within her authority to deny disgorgement for looking at all the facts and circumstances of this case. I don't know what...
I'm sorry to interrupt, but if we send it back for the trial judge to look at this limited aspect of it, and the trial judge says, oh yeah, I find that there was not a license required for the culprit.
If that happens, I still think we can win. I think on an equitable...
That's my question, is wouldn't that just be...
Excuse me?
That's my question. Wouldn't we just be where we are today? If she had said that on the record below initially.
Yeah, I think that if she had just said that, but didn't give any explanation as to why she denied disgorgement, I'd be making the same arguments, counsel would be making the same arguments, because I think that even if there was a license required and it wasn't obtained, there's no statute and no appellate case in this state that says that if you don't have a license, you have to disgorge all of the money that you were paid. The statute simply says you can't enforce your contract. That's all it says. In law or equity, yes, it does. But it's still talking about enforcement. So I don't think it makes a difference. I think that a remand or asking the judge to make a determination about whether a license was required has been waived by the appellant. And I also think it would be unnecessary and it would not make a difference for the reasons that I said, because of the equitable considerations here. Am I into my rebuttal already?
You are.
Okay. I'm going to try in just a few minutes to hit the high parts of the cross appeal. On FDUPTA, there's no actual damages. We cited a number of cases in which monetary harm to the plaintiff in the sense of it costs me more to do something, or you stole something from me, or you embezzled something from me, that's not actual damages. Actual damages, the case law basically says, is the difference between the value of what you got and the value of what you paid, and if you got like a valueless product, then you could get the full refund of what you paid. But what happened here was the sale of dirt had been going on for quite a while, because they needed to get rid of the dirt for this project. The plaintiff alleged in a separate count, separate facts completely, that Jack Weisenbaker and his company sent some invoices out to these buyers of dirt, these third-party buyers, and kept some of the money. The jury found in favor of the plaintiff, awarding $29,500, I believe it was, against both of these defendants. This is the only personal judgment against Mr. Weisenbaker personally. But that's not actual damages. We move for directed verdict and we move for summary judgment on that. That's a legal issue, and we believe that we should have reversal of the FDUPTA claim on that. Secondarily, on FDUPTA, the case law says there's nothing from this court that we could find, but the 4th, the 3rd, and the 11th Circuit, and the Southern District of Florida, we cited cases that stand for the proposition that although under the current FDUPTA statute, you do not have to be a consumer to file a lawsuit, the harm has to be to consumers. There has to be some harm or detriment to consumers. And there simply wasn't here. The only harm was to Riverfront by not getting this $29,500 of proceeds from the sale of its dirt, because
So they wouldn't be considered consumers in this?
no, and that's what counsel argued, that not only, it doesn't matter whether there's a detriment to consumers, we are consumers, but they weren't. They were a consumer of our work, if you will, but not, the sale of dirt was completely separate. They were not a consumer in connection with the sale of dirt. They were to get the money from that, but they were not a buyer. They were not what you would typically call a consumer of dirt. So for those two reasons, we asked the FDUPTA be reversed. Fraudulent lien, we also have two legal issues on fraudulent lien. First and foremost, no damages were proved at all. The statute 713.31 lists the kind of damages that a plaintiff can get on a fraudulent lien claim. One of those damages is attorney's fees incurred in getting a discharge of the lien. I submit that that suggests that if you already sued to discharge the lien and you paid attorney's fees for that, that's part of your damages when you sue for a fraudulent lien. This cause of action was for fraudulent lien. No, not even a request in the complaint for discharge of the lien. In the exact same paragraph, 713.312B, I think it is, it has a prevailing party attorney's fee. So there's two different attorney's fee entitlements mentioned in this statute. One is damages for seeking discharge of the lien, which never happened here, and the other one is prevailing party. Counsel has combined that and said, oh, well, you know, we have a reservation of jurisdiction for our attorney's fees, so that's our damages. Well, that's simply not true. That's under...
Counsel, you've exceeded your rebuttal time.
Okay.
So I will give you 30 seconds at the end.
Okay.
But let's
Thank you.
wrap it up right now. Okay.
Thank you, Your Honors. From a high level, I want to address a few issues real briefly. First, I want to start with the standard of review argument. Jack Weisenbaker is now arguing on appeal in order to avoid the de novo standard that there were mixed issues, but there weren't. If you recall, she couldn't cite where in the record. That's because the record hurts, and here's my point. The parties in the pretrial stipulation stipulated as to issues of law. In the pretrial stipulation, record volume 7, page 17400 through 17402, the parties stipulated in the pretrial stipulation as follows, quote, whether JWCI violated Chapter 489 Florida statutes, and as a result, plaintiff is entitled to relief, count 6 of the second amended complaint. In other words, we agreed and stipulated that as a matter of law, that is the issue for the judge to decide. So the directed verdict standard is still applicable even though the issue went to the judge under the involuntary dismissal standards. So once we stipulated that the judge could determine this issue as a matter of law, and she denied directed verdict, your review is de novo as a matter of law. And once the jury answered the question, the special interrogatory, that this was a stormwater system, then as a matter of law, you could determine that a license was required because we stipulated that this was an issue of law for the court, i.e. you at this level, to decide. So there's no reason to send it back.
Couldn't you have a stormwater system that has a culvert, but the culvert doesn't require a license?
So I wanted to address that because there is a fundamental misunderstanding in that regard because, and I want to address this point, that 15% of the culverts is somehow minor. Less than 5% of our bodies is made up by our heart. Our heart makes up less than 5% of our body. And if it's not functioning properly, we start shutting down, and it can kill us. That is the culverts. The culverts are the heart of this system. And even if you partition the culverts from the stormwater system, the Jacksonville ordinance, the easement that was entered into between Riverfront Associates and the city of Jacksonville specifically refers as to the 100% of the area being a stormwater system. Because if stormwater didn't mix, fresh water, didn't mix with the brackish water of St. John's, everything would die. There are creatures that need, animals that need a balance.
Well, it's very important, but the issue is licensure, right?
Now I'll get to that. So once we agree or anchor off the stormwater system special interrogatory, read chapter 49, section 105, subsection N3. Excavation in a stormwater system requires a license. So you can't even discount that 85%. That's why that issue of the stormwater system, the jury, was so important. That's kind of, I believe, what kind of choked up the judge on summary judgment and had her find those issues to be factual. But that should have gone away once that special interrogatory was answered, because it resolved the issue of 15% versus 85. Put a fact that the whole system, the whole mitigation bank dies and no credits would ever be received from the Army Corps. Put that aside. Once the jury answers that question, it made the entire system require a license to work in it because it was excavation in a stormwater system. And then add this, that to install the culverts was excavation in a right-of-way. To install the culverts in the city of right-of-way, which would require a license as well. So again, there's really no way to partition this work whatsoever. And then again, going back to chapter 49(9) and the penal nature of the statute, to partition would require defenses that aren't available. And so the only correct thing for this court to do was determine as a matter of law that a license was required, that Jack Weisenbaker cannot benefit from its lack of licensure in any way whatsoever, and disgorgement should be awarded. Well, judgment should be entered on count 6, disgorgement on behalf of Riverfront Associates. Thank you, Your Honor, unless you have any additional questions.
Thank you.
Thank you.
All right, 30 seconds to wrap it up.
Very briefly. With regard to this pretrial stipulation that counsel stated, that was waived. If you look at volume 18 of the transcript, which is the post-trial motions, and I'm going to give you the pages, the arguments on the disgorgement were pages 3458 to 3493. I made all these arguments about the equitable considerations, et cetera. There was no objection. There was response. So this pretrial stipulation is a red herring because that was waived. With respect to the argument that because of the jury's finding, that made the entire system require a license, no, that just doesn't fly. It was stipulated below. Only the culverts required a license, and there is a way to sever it by the money. So we're asking your honors to affirm on disgorgement and to reverse on the other 3 issues. The first 2, directed verdict, which is the FDUPTA and the fraudulent lien. The mistrial, I know, which we didn't have time to get into, that would be for a new trial. Thank you.
Very good. We very much appreciate the advocacy today, and we will be in recess.
Thank you.